Hi, I'm Emily and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney MacDonald is, can parents file a state claim against a school if their child is a bullying victim?
Thank you, Emily. Under Connecticut and New York law, there is no definitive answer as to when a school may be liable for an act of student bullying. Whether a parent can prevail on a negligence claim is dependent on the unique facts and circumstances surrounding their child's case. Therefore, it is best to consult with an attorney before contemplating a negligence claim. Municipal employees, including public school personnel, may be held liable for failing to adequately perform ministerial duties. Courts have generally characterized ministerial actions as prescribed actions that do not involve the exercise of judgment or discretion. These types of actions are usually secondary in nature and executed according to established policy, rule, or practice. Examples of ministerial acts include a school's failure to inspect and keep hallways clean pursuant to a Board of Education bulletin, or the absence of adult supervision during recess. The Connecticut courts are divided as to whether a school's failure to take action against bullying when it knew or should have known about the misconduct constitutes a ministerial action. In one case, a parent filed a lawsuit against the local Board of Education, the school principal, and school athletic personnel after the student claimed that he had been bullied and harassed by other teammates during an after-school high school program. The court held that the failure of school employees to guarantee the student would not be bullied or harassed during a voluntary after-school program was not a failure of the employee's ministerial duties. On the other hand, a Connecticut court ruled differently in another case when a student who had been teased on a daily basis had an object thrown at her head, causing severe brain injuries. After the incident, the parents filed a negligence claim against the town, the local Board of Education, and the school, alleging that they had failed to follow their anti-bullying plan. As the school had prescribed detailed procedures for teachers and administrators to handle bullying incidents, the court reasoned that their related actions could be ministerial in nature and allowed the parent to proceed to trial under that theory. While no two bullying incidents are alike, whether a particular action is ministerial is dependent upon the level of detail in the school's anti-bullying plan. I find that a parent will likely have a better chance to prevail on a negligence claim under a ministerial action theory if the school fails to discharge a responsibility that was spelled out in the plan in such exquisite detail that it eliminated or marginalized a school employee's judgment or discretion. Meanwhile, the New York State Court of Appeals has found that a school was negligent when two sisters were beaten and terrorized on school property, and one sister reported the incident to a teacher, but no action was taken. The New York State Court of Appeals found that the school had recognized the need for and put into effect a security plan and thus breached its duty to provide the plaintiffs with adequate supervision at a time when such supervision was most critical. Now, municipal employees are granted qualified immunity with respect to performance of governmental acts, which are actions that benefit the public and are discretionary or supervisory in nature. Generally, there are three exceptions to the granting of this immunity. The first exception is that actions that involve malice or intent to injure. Second, statutory causes of action against the municipal employee. Or three, a public employee's failure to act directed at an identifiable person subject to imminent harm. All right. To satisfy the third exception, so as to deprive a municipal employee of qualified immunity, plaintiffs have to show that there is one, an identifiable victim, two, imminent harm, And 3, a public official to whom it is apparent that his or her conduct is likely to subject that victim to harm. For school purposes, an identifiable person has traditionally included school children attending school during school hours. To satisfy the imminent harm element, the particular misconduct must be limited in time and geographical area. With respect to the time component, the action must be temporal or of short duration. Risks that might occur at some unspecified time in the future do not constitute imminent harm. In applying this definition, one court has held that an incident where a student tripped another student during recess did meet the requirement because recess was a defined period of time that took place after lunch every school day. In terms of the geographical area, the conduct has to be confined to a specific location. Therefore, if the action has the potential to occur at multiple places, then it would not constitute imminent harm. As I have indicated, the presence or absence of qualified immunity is a highly fact-specific inquiry. Therefore, if parents want to proceed with a claim against school officials, it would be best to consult with an attorney in order to evaluate the respective strengths and weaknesses of such a claim. Feel free to contact me if you would like to discuss your matter further.
Attorney MacDonald is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney MacDonald at LMacdonald@mayalaw.com, and please visit mayalaw.com for more information.